Great. Well, thank you very much for coming today to this Bright Blue Oral Evidence session for our Conservatism and Human Rights project, which is a year-long inquiry which is looking to gather and then propose ideas around three central themes. So the first is tackling discrimination in its many forms, whether it's sexual, racial, gender. Another theme is around the British Bill of Rights and how we can strengthen human rights through the new British Bill of Rights. And thirdly, looking at how we can protect and enhance human rights abroad and the role of Britain and the Foreign Office in particular in that. And there are particular elements of that third strand which we're interested in, including torture prevention, which is why we're focusing on today, and we've invited you here. Just to say that you'll be interviewed by a panel of commissioners here. We have been having different commissioners come in at different points because the others are MPs. So we may have Dominic Grieve coming back at some point, but he's been in the House and with us this morning coming back, but he is the MP who's down to help us in this session, so he may come at some point. To tell you that you are being filmed and also your comments will be tweeted and a transcript of this discussion will appear in our final report, but it will be made clear that you don't necessarily endorse all of our findings or Bright Blue's vision, that you are here in an independent capacity. So if I could ask you, well actually I'll just say Nigel Fletcher is our head of research here at Bright Blue. I'm Ryan Shorthouse, the director. Kate Maltby is an associate fellow at Bright Blue, and we have James Dobson, who's a researcher at Bright Blue. So we're all involved in pulling together the final report for the Commission to approve. So if I could ask you to tell us who you are, where you're from, and perhaps your sort of introductory remarks. So Carla.
Hello, I'm Carla Ferstman. I'm the director of Redress. Introductory remarks are to say that I'm delighted to be here. I think that this is a hugely important topic. I think human rights, as a general principle, knows no political affiliation. It's beyond politics. And I think it's extremely important that conservatism, as you will, is embedded with the human rights policy. With respect to torture prevention and the work at Redress that we've been working on for many years, from a foreign policy perspective, I think it's quite important to state that, firstly, the United Kingdom government has had a prevention of torture policy for many years, which ended in 2015. That is a shame. Having a policy was an important way in which to safeguard the work, to continue to engage with the work, and to move forward with the work. Secondly, the United Kingdom's main statement on torture has consistently been, we abhor torture. This is extremely important. We hope that this will come into play with current governments, which should adhere to the same principle, but we think that the government should go much further. What does it mean to abhor torture? What are the practical implications of that? Firstly, I think it's really important to underscore that President-elect Donald Trump has reportedly said that he would bring back a hell of a lot worse than waterboarding. This has to be an issue for the United Kingdom in terms of its foreign policy, certainly if it continues to abhor torture. It's important that the United Kingdom is not afraid of raising torture with its allies, be that the United States, be that Bahrain, United Arab Emirates, Saudi Arabia, or any other country. With respect to a number of issues which we view of particular concern, the United Kingdom's response to wide-scale allegations of torture and other abuse by the military in Iraq has been to vilify the lawyers and threaten to derogate from the European Convention on Human Rights, to avoid dealing with what has been termed spurious claims by the claimants. This is a problem, particularly when there are ongoing investigations into extremely serious matters and numerous serious matters involving torture and other abuses. It's inappropriate for any government to make any comments about the nature or validity of claims whilst there are ongoing investigations. Second issue of concern for redress has to do with counterterrorism. There is still no public scrutiny or accountability about the alleged role of the United Kingdom government and the intelligence services in the extraordinary rendition of certain individuals and the role of MI6 investigators in interrogations in secret detention places. Of course, there are inquiries ongoing. We believe that it's vital that these issues are fully canvassed in the public domain and that there should be accountability as appropriate. Additionally, there are British nationals and dual nationals who are being tortured or at risk of being tortured abroad. This should be of absolute concern to this government and to any British government. No individual, no British national, dual national, should be put in harm's way whilst abroad. We hope that the United Kingdom will increase its support to nationals abroad through consular and other forms of assistance. We also think that it's absolutely crucial that in terms of any support that the United Kingdom provides to foreign governments in the areas of security and justice assistance, that is done as transparently as possible, and that there can be no way in which any such support is used to facilitate torture or related abuses. Thank you.
Okay, thank you, Carl. When you say at the beginning, just a point of clarification, that the FCO has no longer got a policy on torture prevention, are you saying the government has no policies, or are you saying it's no longer a priority?
The United Kingdom had a very specific anti-torture policy on how to prevent torture, which was in written form, which underscored how it delivered assistance, which formed part of its foreign policy for years, but that ended in 2015.
Okay, Ken.
I'm Ken McDonald. I'm chair of Reprieve, a Lib Dem peer and warden of Wadham College in Oxford. So Reprieve's obviously been quite active in this area, as well as being an NGO that campaigns against the death penalty and represents people on death row all over the world. It also represents people who are have been the victims, as we would see it, of some of the more egregious examples of behaviours under the so-called war on terror. We've done quite a lot to try and get people out of Guantanamo Bay, and have got a number of people out of Guantanamo Bay, and we've also represented people who have been victims of torture around the world. One of the things that was very apparent to me when I was DPP, and this is between 2003 and 2008, and visiting various difficult parts of the world, was the extent to which our American misbehaviour, as it might be characterised under the war on terror, was turned back against us. So people would say to me, why are you coming here lecturing us about human rights when you have Bagram and Guantanamo Bay and waterboarding? I found it quite undermining, and I think it was undermining of our position in the world. And it seemed to me during those years that whereas really we should have been wanting to present ourselves as a beacon of us and the Americans, the West, as a beacon for human rights and democracy and all the rest of it, instead we became a symbol of hypocrisy, and I think that was enormously damaging to us. I don't think it made us any safer. I think it made us less safe, much less safe, and I think we lost, to a vast degree, the battle for hearts and minds, and I think that some of these behaviours caused many millions, literally tens of millions of people around the world to see us as an enemy where they might not have done so. None of this is to say that we don't have to defend ourselves against terrorism and against extremism. Of course we do. And a large part of my job as DPP was prosecuting and having locked up terrorists, and we did that to great effect, and we did it quite relentlessly, but we did it within normal due process rules. We didn't have special courts, we didn't have vetted judges, we didn't have vetted juries. We had normal courts, normal criminal processes, and dealt with it that way. And I think that around the world we also need to observe a modicum of due process. By that I don't mean that the response to terrorism around the world is a criminal justice response. Of course it isn't. If you face a militarized attack, your response to it sometimes has to be militarized. The appropriate response to terrorism around the world is not just a criminal justice response. It can be a military response, it can be an intelligence response, it can be a diplomatic response, it can be a violent response. But I don't think that torture has any place within that violence. The violence that I'm talking about is lawful violence in the way that self-defense is lawful violence. Torture is unlawful for two reasons, I think, well, perhaps three. One, it feels morally wrong to inflict deliberately pain upon a helpless prisoner, and to do that with all the auspices of the state behind you. That seems and feels morally wrong. Secondly, such research as there is appears to indicate that the information you get under torture is not reliable, and that's not surprising, because people generally under torture one would think, be inclined to tell their torturer anything they thought the torturer wanted to learn. And three, it's a terrible, terrible propaganda tool to involve yourself in torture, particularly when the line we've drawn in the world is, in essence, between Enlightenment values and non-Enlightenment values. To employ torture in defence of Enlightenment values seems to me to be a tragic contradiction, of which no good will come. I have, since Mr. Trump made his statement, and quite recently, I've discussed what he had to say about waterboarding with people in British agencies at a senior level, and their reaction is that if he goes down that path, we must not. And I'm comforted by that, and I'm sure they're sincere in that, and I hope that our government would also take that view and be sincere in it. Not only that we should not, but that we should tell him, if he does, that he's wrong to do so.
Okay, thank you, Ken. Sonia.
Thank you very much, Ryan, and Bright Blue colleagues. My name is Sonya Sceats, and I'm the Director of Policy and Advocacy at Freedom from Torture. We are one of the largest torture rehabilitation centres in the world, and also one of the most long established. Last year, we provided direct care to almost 1,300 survivors of torture here in the United Kingdom, and produced hundreds of forensic medical reports as well. We're kind of a leader in the torture rehabilitation world for the use that we make of those forensic reports to hold torturing states accountable, particularly at the international level. And I'd be very happy to take questions on that. But I would like to confine my opening remarks, I guess, to a case for Bright Blue and for people within the Conservative movement to resist any backsliding on the torture ban in the context of the big public debate that we are having about the future of protection for human rights in this country. In some ways, it's sad that that has to be a conversation we have, but at least for 4 reasons we must have that conversation. My colleagues on the panel have both alluded to the remarks of the President-elect in the United States during the campaign on torture. And so it's very front of mind for a lot of people in the political sphere at the moment. Secondly, again, as my colleagues have emphasised, we haven't yet succeeded in removing the stain on the reputation of Britain that came along with the complicity in the torture practices that Ken was describing. Thirdly, and in some ways more politically, we are in the midst of a relentless attack being driven by the Ministry of Defence on the extraterritorial application of the Human Rights Act to the conduct of British troops abroad. This is so deeply problematic. For a start, it is an insult to those in the military to suggest that they are incapable of complying with a basic standard against torture. It is undermining of those inside the military who are trying to do the right thing and to pursue torture prevention strategies on the inside. It would absolutely, if it came to pass, remove avenues of redress for survivors. And finally, it's also sort of misleading, I think, because presumably extraterritorial application of Article 3 would go hand in hand with removal of the extraterritorial application of Article 2, which of course is a key protection for troops who are being sent out into battle without the necessary protection. And I don't think that that's something that is being aired properly on that side of the debate, and that's something you might want to think about. The fourth reason that we really need to have this conversation, I think, is that even within the centre-right, there is an ongoing conversation about whether the absolute ban on torture, with its implications for removals, extradition cases, deportation cases, removals, etc., should be relaxed. I mean, and even in the essay collection that Bright Blue produced earlier this year, Damien Green MP was floating the idea that we needed to look again at this, despite it being an incredibly well-settled area of law, and that was terribly concerning to freedom from torture and to many people who worry about these things. I would make the point that, from a conservative perspective, Britain has a very long and noble history of leadership on the torture ban. From the 13th century onwards, torture was phased out of the common law long before those on the continent followed suit. And of course, it travelled into the Magna Carta, which last year many Conservatives, among many others, celebrated the 800th anniversary of. This, of course, doesn't mean that torture didn't happen in Britain, but a norm was born that has continued to shape the famous British justice system across the centuries, and I believe contributed to what Theresa May last year described as the UK's status as a beacon of hope worldwide when it comes to the idea of how one treats our fellow human beings. And of course, it was British conservative lawyers who, for the most part, wielded the pen when European Convention on Human Rights was drafted, including the very, very elegantly simple prohibition of torture, the absolute prohibition of torture that we find there. So in closing, I would say that there are sort of 3 points from freedom from torture's perspective against any backsliding through kind of tricky kind of meddling with the extraterritorial scope or meddling with the application of the torture ban in removals cases. And they are, firstly, that it would be a betrayal of a proud British tradition. Secondly, it would rub salt into the wounds of survivors, so many of whom we are caring for here in the United Kingdom. I cannot tell you how disheartening this debate has been for survivors of torture, and we really do invite Bright Blue, your commissioners, to come to Freedom from Torture and to speak to our survivor activists themselves and to hear from them directly on this. And then thirdly, to connect back to a point that both Ken and Carla made, I believe very, very strongly that it would undermine the UK's international reputation. We have a government at the moment committed to promoting a rules-based international system as a sort of a pillar of our foreign policy. And in a context where the United States is potentially about to start wavering on this and open up a big political and moral crisis about this issue, British leadership on this issue is needed now more than ever. Thank you very much.
Okay, thank you, Sonia. Just a point of clarification. So, on the derogation of the ECHR in the situation of armed forces, now one thing that people like Dominic say is it's not going to make a difference because claims will still come against soldiers, for example, through criminal law. So there will still be recourse. Will there still be recourse for people through that route?
So 2 points. Firstly, Article 3 of the European Convention on Human Rights is non-derogable. Right. So that is not an obligation inside the convention that the UK can just put on ice. So that's a kind of a legal point. Secondly, it absolutely will make a difference because, as we well know, for very many survivors of torture and other forms of ill treatment, the civil claims route is the only claim route available to them. I mean, just look at the rendition cases. The CPS has spectacularly failed to bring any prosecutions in relation to those allegations, despite very strong evidence, we understand. And so in that context, having these civil routes is incredibly important as an accountability tool and as a means of delivering redress to survivors.
Okay. Can I ask a question about the just how much torture? Are we seeing a reduction worldwide in the use of torture? Are we seeing an increase? And how do we measure that? What are the data sources?
I mean,
And to anybody, basically, though.
I can sort of speak to Freedom from Torture's experience. I think it's very, very difficult to quantify levels of torture around the world, precisely because torture tends to happen in secret. I can tell you that Amnesty International reported torture in 122, or ill treatment, in 122 countries last year. We, for our part, worked with 1,300 people, last year, who came from 66 countries. And so I think torture is very, very widespread, difficult to quantify. But in our experience, referrals to us as an organisation are not going down. They've in fact been increasing over the 30 years we've been in operation.
I think one troubling development in Syria and Iraq is the use of glamorising torture as a propaganda tool to attract, for two purposes it seems. One, to terrorise the local population, but also, more disturbingly, to attract support. So the sort of videos that we've seen being posted on the internet of people being tortured and killed in the most brutal ways, defenceless people usually with their arms and legs bound, seem to have those twin purposes, not just to terrorise, but also to attract. And there is some evidence, I think, from the sort of tweets and emails of people who are attracted to go to Syria and Iraq, that they do find that sort of material enticing. And I think that's a disturbing development, the sense in which you don't necessarily have to hide torture because it's something that has to be done in secret, but it's something that can be done very publicly as a tool of political propaganda to attract and entice support. That's probably happened in other periods of history, but it's certainly happening now.
Very interesting.
Just to say that the way in which torture is being practiced continues to evolve. But also the very classical kinds of torture in police stations to get a confession, have not abated in many parts of the world. And it's not only in a few countries, it's widespread. But you have torture in conflict, you have growing torture by non-state actors, both in the context of conflict and outside of that, because of the progressive use of private security companies in policing and detention functions. You do have torture practices happening by those types of actors under the guise of authority.
So are you referring to, say, in the UK, sort of detention centres and things like that? Is that what you mean?
Well, there are allegations concerning immigration detention where acts which would amount to torture, including sexual exploitation and abuse, have taken place. There have been, and that's another issue, there's been an underuse of the torture definition in investigations and prosecutions. So there have been prosecutions in relation to some behavior, but not for torture, for other crimes, lesser crimes. So that's another issue.
Okay. Nigel.
I want to go back to something that Ken said about the sort of the reasons that torture is wrong, and the reasons it takes place. I mean, on the one side there is, as you said, of the propaganda use, which is quite disturbing. But secondly, the sort of judicial use. It's clearly acknowledged to be something which would lead to an unsafe conviction because the information cannot be trusted. In a judicial system which is trying to get a conviction, so in a sense, in a corrupt and pernicious system, you can understand why it would be used in that way. But for intelligence purposes, clearly the objective is not to persecute somebody, it is to obtain accurate information. So is there a recognition within the intelligence community worldwide and amongst states that for that purpose it is not an effective tool, and that it's not something that should be pursued, and also on the judicial use, whether it is acknowledged that it is wrong for that reason, that it leads to coerced testimony?
I I can speak best about the British and American intelligence agencies. Clearly there were practices formalised in the US intelligence agencies and justified by legal memorandums from senior lawyers in the White House, I think, State Department, they were practices that we would regard as torture, waterboarding being the best example. It's certainly true that within American intelligence agencies, even while they were being practiced, those practices were controversial. And there were many members of the American intelligence community who found those practices extremely disturbing and opposed them. It won't surprise you if I say that the people who supported those practices tended to argue that they resulted in reliable information. The people who opposed those practices tended to argue they resulted in unreliable information. So far as the British agencies were concerned, there was some evidence through High Court litigation, as we all know, that British intelligence officers may have visited people who were being subject to mistreatment roughly around the time they were being visited, and questions were asked about whether those British intelligence officers should have realised what had been going on, and there are arguments on both sides there, and I don't want to come down on either side for the purposes of this evidence, because I don't know, and I'm not equipped to answer that. What I do know from having had close relationships with people in British intelligence agencies at the highest levels during those years was that there appeared to be, and I was convinced that there was, a strong culture within those organisations which was hostile to a great deal of what the Americans were doing, and concern about it. Now, how that played out on the ground is a different question, and those were years that I think people will look back on as being difficult, sometimes chaotic years in which very sensitive judgments had to be made, sometimes at great speed. None of this is to justify wrongdoing. I'm not suggesting there was wrongdoing. I'm just saying that's the reality. That's how it felt at the time. But I'm sure that there is a strong institutional culture in British intelligence agencies against those sorts of practices, and I'm sure that there is a strong view in British intelligence agencies that the material you obtain from torture is unreliable, but that's not the main reason for opposition. The main reason for opposition is that it is just wrong. It's illegal, but it's just wrong. It's wrong for the state to be deliberately inflicting physical pain on helpless prisoners. It's just wrong. It feels wrong, and we shouldn't do it. And whenever I'm asked about the ticking bomb example, I always repeat that. It's just wrong, and you have to draw a line, and it's wrong, and we don't do it. A slightly more difficult question arises, if I could just open this up slightly, where you come into possession of material that may have been obtained by torture, but which could be useful for an intelligence purpose. So, for example, you come into possession from a piece of intelligence from a foreign intelligence agency that might have been obtained by torture, but which tells you there's a man sitting in the East End of London trying to build a chemical weapon. Now, it seems to me the answer in that situation is you act on the information, and you go round to his house and you arrest him and you dismantle his weapon. Some people, and maybe colleagues here take a different view, I always felt as DPP that if you received that sort of information, you had an obligation to act upon it. You would never rely on it in court. You would never call torture evidence in court. But sometimes when you're talking about the use to which material that comes into your possession should be put, the moral imperatives aren't quite so simple. As to the view of the courts is that the first test of the admissibility of a confession is that it's voluntary and therefore reliable. And that's why judges rule out torture evidence, because it's involuntary and it's unreliable.
Carla?
Just to say that the US Senate report, which examines in quite a lot of detail the practices in the United States, came to the conclusion that no useful
That's right.
materials came out of the torture practices, which I think is useful to underscore. Though once again, I would absolutely adhere to what Ken said, that that's not the primary reason not to torture. The primary reason not to torture is because we're above that.
Kate?
Ken, you just presented a hypothetical scenario in which you come into information that may have been obtained by torture, by using torture by a third party. Are you aware of that scenario having played out in Britain under the radar?
I am aware of material which we acted upon to good effect that came from countries that routinely practice torture.
And does that not challenge your assertion that torture doesn't work?
No, because what you're doing with the use of intelligence is to test whether it is true. Sometimes it might be. I'm not saying that people never tell the truth under torture. Sometimes they do, sometimes they don't. The problem is you don't know. But this would be, the sort of example I gave you. You go round to this address and you see if there's a man there building a chemical weapon. If there isn't, no harm done. If there is, you're going to stop a major harm.
The issue is whether the coercion of torture causes someone who would otherwise not tell the truth to tell the truth.
Yeah.
And there's absolutely no evidence to suggest that the extra coercion of torture creates truthfulness.
Yeah.
Okay, unrelatedly, but this one's brief. To go back to Ken, given your faith in the scepticism of the British intelligence community towards torture, how optimistic are you that we, to put it crudely, will be able to stand up to a President-elect Donald Trump on this issue?
Well, I'm very confident. I'm very confident that we won't start torturing. Let's suppose. I don't think he will. I don't think this is going to happen. I think this is something that President Trump.
But I'm responding to Carla's fears.
Okay. But I don't think it's going to happen. But if it did happen, let's suppose President Trump ordered the CIA to start using waterboarding again. I don't believe there is any prospect at all that a consequence of that would be that the British would start waterboarding. And I think it likely that the British would challenge the Americans and argue with them about it. The question is whether, if they're doing it, we, because we have such close contact with them and because we're interested in the same people, then find ourselves contaminated by that process, which appears to be what may have happened in the past. I mean, very many of these individuals are of interest not to just the Americans or just the British. They're of interest to both of us. Many of our criminal prosecutions in the UK were prosecutions in which the Americans also had an interest. So if the Americans are waterboarding people, some of the people they're waterboarding are going to be people that we have an interest in. And that's the risk. The risk is of a contamination in that sense.
And a complicity. Because if an intelligence officer is sitting in the next room while someone is being tortured and then goes in to have a discussion after the person has been softened up, that's potentially a complicity in the torture.
But I think inherent in what I'm asking is the question of how far British intelligence services would be prepared to sever links and to give up access to information in order to remain free of that.
It's very difficult to conceive of us severing links with the Americans. The intelligence relationships between the Five Eyes countries are very close, and in particular between the British and the Americans. I mean, everyone knows this, and the reality is that we cannot sever intelligence links with the Americans, and we won't do so.
So finally, just thinking about the Foreign Office in its role in terms of pushing for a reduction in the use of torture worldwide, have we seen progress in the role of the British government pushing for that? And what more can and should they be doing to sort of see torture prevention worldwide? So obviously, one thing that you have talked about is leading by example, and that the actions in the mid-noughties were counterproductive to that. But are there any other examples of what could be done by the government to help reduce torture?
Well, one of the areas where the UK government has been good over the years has been to promote the UN optional protocol to the Convention Against Torture, where it's taken a leading role both politically and supporting of civil society groups who have been working with governments at the domestic level to put in place monitoring of detention centres. There's a range of work that could continue to be done on that, but also on a range of other multilateral initiatives where the United Kingdom has traditionally played a really important role. But that needs to be matched by the leading by example.
Okay, Sonia?
Yes, would be my answer, and I think we wouldn't be shy in saying that there is a very strong perception that since William Hague left the Foreign Office, that there has generally been a downgrading of human rights in the role of British foreign policy. That manifested in so many ways, including the removal of the torture prevention strategy that Carla was alluding to. But it also has resulted in the marginalisation of the human rights expertise pool inside the Foreign Office. That could really easily be reversed. And for us, that could take very practical effect. I mean, we would love to see the UK in its bilateral relations with key states taking a much stronger stand on torture prevention. And I'll just reel off for you some of our top countries of concern. Sri Lanka has been the #1 country of referral and of clients that we've been working with for more than 4 years now. We would love to see the United Kingdom seriously pushing Sri Lanka to adopt a credible torture prevention program. We're seeing very little evidence of that, despite very close relations, strained but in other ways close relations between those countries. We would love to see the United Kingdom taking much more of a role in pressuring Turkey, given all of the kind of regression that we've seen there in the aftermath of the coup attempt. The Special Rapporteur on Torture recently was unable to conclude a visit there. Why isn't the UK doing more to open that door, to get the Special Rapporteur on Torture in to go and monitor those facilities? And then finally, Iran. Iran is our #2 country of origin for people who we work with. There are incredible political opportunities potentially that follow on from that nuclear deal. Human rights, there's not a lot of evidence that that has been part of the conversation. The torture situation inside the Iranian prison system is absolutely horrific, and we would love to see, a dialogue happening at various highest levels. There are examples where we're just not seeing, if you like, the practical impact of that commitment that Carla was referring to, translating into practice. The Preventing Sexual Violence Initiative, I know you've just had an evidence session touching on those themes, but this absolutely is an area of best practice, and it's an area that has been spearheaded by conservative thought leaders. This is something that Freedom from Torture feels extremely strongly needs to continue. It's a pioneering style of diplomacy. We have been much more campaigning oriented, public diplomacy, tackling things that are such a problem from a survivor perspective, like stigma. That's a big focus for Baroness Ainley at the moment, the lead for government on this issue. But we have been incredibly impressed from the inside to see the way in which, over the short life of that initiative, the Foreign Office has begun to take seriously and to properly understand what taking a survivor-centric approach would look like. So in the beginning of that initiative, we have a number of really articulate, empowered survivors of torture who do survivor activism work for us through a network called the Survivor Speak Out Network. And at the beginning, they would always be invited to come and join a panel with William Hague at the United Nations or at the Conservative Party conference or wherever it would be to, if you like, humanise the issues and share a perspective. And over the course of that initiative, that has really translated from not just having sort of a survivor as part of a panel, but a voice at the top table. So Kolbasi Hoasu, our lead for that network, now sits on the steering group, advising on policy and implementation, and not just being there to talk about how important these things are for survivors in some general or very highly specific way. And this is really best practice internationally. And then finally, this is and I endorse everything that Carla was saying about all of the kind of the treaty-based steps that could be taken and the multilateral avenues. But the UN Voluntary Fund for Victims of Torture has had declining contributions over many years, and it's really struggling at the moment to provide the support to organisations who are supporting survivors of torture all over the world. The UK did recently increase its contribution. We would like to see that increased so much more, and that would be a very symbolic as well as very practical step that we think the government could take.
Very useful, Sonia. Thank you. Ken?
Well, I agree. I mean, with what you said about the Foreign Office, I've always been very impressed by their commitment in these areas, and indeed at Reprieve we found them to be a very constructive and capable and helpful collaborator in many of the things that we're doing, and they're always willing to engage with us, and we have very useful meetings, and I think very highly of them, frankly. When I was DPP, whenever I visited another part of the world, I'd receive a human rights briefing from the Foreign Office, pointing out the issues in that country, lines that might be helpful, and an invitation to raise these matters with my interlocutors. And that was, I did this in China, numerous countries, from China to Bahrain. So I found their commitment, this was 2003, 2008, to be high, and I certainly found that under Baroness Warsi and the coalition government had a similar commitment, and I thought that they were equally engaged with these issues. So I think that the Foreign Office here is probably a model for foreign ministries around the world in terms of the way it takes these issues seriously and engages with NGOs and with other interested parties, and seeks to advance these ideas and these values around the world. I think they are committed to it, and I think they put effort into it.
Okay, thank you. That's been an incredibly rich and useful discussion. Thank you for sharing your time and your thoughts with us. And the films will be shared with the other commissioners as well, and they will be very helpful for our policy formulation sessions, which are coming up in the coming months. Please do stay in touch with us and feed ideas in as we go into this next critical stage. But a big thank you for coming today. Thank you very much.
Thank you.